We are not challenging the judgment of Justice Mrima. We are challenging the implementation of that judgment. The judgment was very clear that only the DPP has the power and the decision making in who should be charged. The judgment also was very clear that only the DPP has the power to draft the charge sheet. And 3, that only the DPP has power to present that charge sheet before the court of law. The question now that we are posed before the court is 1, has the DPP complied with that? Yes, he has complied by drafting a charge sheet. That charge sheet was supposed to be in use as from Monday, because any police charge sheet was an illegal document that was in place. And therefore, we are facing, number 1, every Kenyan knows that if one is charged with an illegal charge sheet, that is a ground for appeal, and that is a ground to acquit thieves, criminals, and murderers. A famous case of the EACC that proceeded without a complete commission when Waziri went to court and challenged it. All the matters that had been proceeded without the input of the commissioners were declared an illegality, and all those people were released. From Monday to date, Kenyans are taking place in court through an illegal charge sheet, one that is prepared by the police. All those people will be declared a mistrial, and that will be a serious criminal justice question to the country. Number 2, the law defines that a charge sheet, 1, must be gazetted in the Kenya Gazette. It is an accountable document. What the DPP has provided for has not been gazetted for it to become an accountable document. 3, the Constitution provides the symbols to be in such a document. The logo of the DPP is not one of them. 3rd, Section 137 provides for the ingredients and the components to be in a charge sheet. The first one is that once the person deciding to charge has made that decision, he must do what is called a statement, a caution statement, and statement under inquiry. These are provided for under the out-of-court procedures, rules of 2009, and annexure in the schedule of the Evidence Act. That the statement of caution can only be taken by a police officer in the rank of above an inspector of police. That statement is to caution and inquire from the person to be charged. Who is going to do that in the office of the ODPP? That is provided for in the Evidence Act. That inspector of police must do that. 2, after somebody has been cautioned, he must be given the charge sheet in compliance with Article 50 of the Constitution, Fair Administrative Act. One must be told why he's being arrested and why he's being charged. The question is, this is now, the charge sheet is going to be drafted at the ODPP office. Do they have those inspectors of police to administer charge and caution statements? 3rd, upon the decision to charge has been arrived, the person must be taken fingerprints. Fingerprints are normally taken and kept at the registry of the DCI, that he's the custodian of all fingerprints in the country. Does the DPP have that capacity? Fourth, the person to be charged must be entered into a charge register. A charge register is a register that captures all Kenyans and everybody who has been charged. That is in the custodian of the police. Is the DPP having that charge register? Fifth, for criminal offenses related to sexual offenses, a special register is retained of anybody who has ever been charged with a sexual offense. And that register is a document that is permanent, retained with the police. Is the DPP having that? Sixth, this person, after he has been charged, after the charge sheet has been drafted, he must be arrested. Once the charge sheet has been signed, he must be arrested, to be kept in custody, or to be given police bond for him to appear in court within 24 hours. Who will effect, once the charge sheet has been done by the DPP, who will effect the arrest? The DPP has, the state councils don't have the power to arrest. Will they make a charge sheet, then send it to the National Police Service Commission for the arrest? That is another dilemma that we have. Next, 6-7 is the antecedent. Previous records must be in the charge sheet. Who will provide the previous records, because the police and the DCI do not have now any legal capacity to draft? So, those previous records, when will the DPP and where will he get previous records? The charge sheet that we have put across bears the following details. The ODPP number 2, ODPP form number ODPP form 2. Nowhere in the ODPP Act is the ODPP Act providing provisions for creation of forms. They are in the police standing orders. On what basis? 8, the judge never declared Section 137 of the Criminal Procedure Code as unconstitutional. The law is still there. Therefore, under which provisions is the charge sheet that the ODPP is trying to make coming in? 9, actions of such magnitude demand for public participation of all the key stakeholders. Behind me is a battery of Law Society of Kenya members, the advocates. What the advocates involved as part of the criminal justice system in the drafting of that document. Article 10 demands participation of all key stakeholders. Was this judiciary a key consumer of the charge sheet involved in that decision to make that charge sheet? Were the citizens involved in that positioning, drafting that charge sheet? 11. We have looked at presidents, previous presidents, found out that the Office of the Director of Public Prosecution has had the luxury of having 2 logos. One under Waziri Tobiko and the other one now under the current DPP. If it continuously proceeds, the question, and this is a tradition worldwide, it is the republic versus an accused person. It started from the common law that it was Rex versus the republic. The charge sheet has never been the DPP versus an individual. It is the republic. It is Kenya that is aggrieved, not the DPP. The offense is against the republic. That is why it is the republic that arrests, it is the republic that charges. That is why the charge sheet, the current charge sheet, the symbol, the logo is of the Kenyan government, the Republic of Kenya coat of arms. So this one, when we are being told it is an offense against the DPP, who has ever committed an offense against the DPP? Everybody commits an offense against the state. In the charge sheet, we have seen there is an ODPP station number. All stations, police stations, are gazetted stations. ODPP offices and any government office is not a gazetted office. So when the ODPP puts that the ODPP office is now a station, have the offices of the ODPP turned into police stations. They must then be gazetted so that they qualify to be police stations, if that is his intention, to make that a police station. Lastly, from Monday to date, very many suspects have not been charged. Today we came to court to represent our client, who was to take plea. Up to now, the charge sheet has not been presented to court. How many charges this country, how many arrested people will be released within the 24-hour rule for failure to take plea because there is no charge sheet in court? 13, we are raising one question. The ODPP State Council is the one going to draft and sign the charge sheet. Once the charge sheet has been signed, previously we could summon the investigating officer to defend the reason as to why he charged that person. Now, the ODPP, by signing that charge sheet, they become witnesses. Can a witness again be the person to prosecute? All the police will do will say, I'm not the one who decided. I only investigated. Ask the person who drafted the charge sheet. Are we going to get a serious challenge in criminal law where the DPP is a witness and where the DPP is prosecuting? That is the challenge we are pushed to the court, raising those pertinent questions that the purported document called a charge sheet by the ODPP is a clear illegality. It must comply with Article 137 of the CPC, must comply with the rules out of court procedural rules under the Evidence Act 2009, where the investigating officer must administer charge and caution statements. This is a serious indictment to the criminal justice system.